My talk is all about restrictive covenants in the context of the employer-employee relationship. I hope that I come to this with a degree of expertise because my practice is predominantly both BPC work and employment law. So I see this on a relatively frequent basis and I see the ups and downs and the trials and tribulations that can arise out of an employment relationship. There are, just to summarize, various types of restrictive covenants. Now, I'm not going to go through all of these in any particular detail because we all know that a restrictive covenant is a contractual clause which seeks to limit or prevent how an ex-employee behaves upon the termination of their employment. And there are various categories of restrictive covenant. The first one up there is not particularly a restrictive covenant all of the time because there is a common law right to protection to your confidential information. And you may think that if a client comes to you and you can formulate a claim on the basis of a breach of confidential information, that might be a more attractive option. There are non-compete clauses, restrictions in working for a similar employment for a competitor. Non-poaching does what it says on the tin, preventing poaching of former employees. Non-dealing, preventing dealing with suppliers, customers, clients, etc., regardless of who approached the other. And I emphasize that because it's ever so slightly different to the last of the potential restrictive covenants of non-solicitation, which is the prevention of poaching suppliers, customers, clients, and similar, i.e. positively going out and looking to take those people from your ex-employer. As we all know, it's not uncommon to find a combination of these types of restrictive covenants in any one contract. And it's really important I emphasize that because if, for example, you are faced with a client who comes to you and says, I want you to draft me a contract with some pretty solid restrictive covenants in it. First of all, I've yet to see a contract which contains what I would describe as solid restrictive covenants. We can only do our best, it strikes me, because they are nearly always open and susceptible to challenge. But you need to look at the restrictive covenants you're putting in there in the round. Are they holistically too restrictive? Because one may impact upon the other if you take it to court and you're asking a judge to find that they're a reasonable restraint of trade upon an ex-employee. Now, what is a reasonable restraint of trade? This is where I could have gone into about 3 hours worth of lecture on the law. I'm not going to, as I said. The burden is on the employer to show that there is a reasonable restraint of trade imposed by the restrictive covenant. There are recognised category of legitimate interests of the employer which the law will uphold and protect. And I've listed those there from A through to C. But I do pause there and I refer you to the handout at paragraph 8 because that's not necessarily a closed list. And I think it's worthy of referring you to the case of Donné Day & Co Limited in Dalpin. Because whilst they are the recognised ones, it's not necessarily a closed list and there is room to argue for further legitimate interests in any particular set of circumstances. What is a reasonable restraint of trade? Well, that is a balancing exercise. One needs to look at the legitimate interests of the employer, which are being exercised or protected, as against the individual's right to freedom of movement, freedom of trade, and frankly, freedom to be employed and to make a living, because that is ultimately what is being interfered with. As I said, I tried to be practical about these seminars, and if you look to paragraph 10, put aside the law for a second. I would hope that paragraph 10, if you have a client comes in and you're looking at a restrictive covenant and you're trying to work out, is this or isn't this likely to be enforceable, that paragraph 10 gives you at least a good starting point of the kind of things you'd be looking at to determine whether that is likely. So without reading them, what is the business and how important is it to the business that their interests are protected? The geographical scope of the restriction, the time that the restriction is said to exist. Now, I pause there because it is not always the case that the shorter the restriction, the more likely it is that it's to be enforceable. You may have a very short-lived restriction, but which is extremely onerous. For example, you cannot, within 3 months of leaving your employment, be employed anywhere ever in the country. That is of itself likely to be an unenforceable restriction, despite the fact that on its face, 3 months is not a particularly long period of time for a restriction to exist. Who's the employee and what's their seniority? This can be a difficult one because Depending upon the industry within which your client works, this may have more or less bearing. One, as a general rule, I would say, tends to find that if the more senior the employee, the more likely it is the restrictive covenant is enforceable. But that isn't always the case. You have, for example, lots of industries, such as in the energy sector, where there are people who, on a day-to-day basis, have direct contact with important customers and clients, making lots of money for their employer, who do not hold particularly senior positions, but nonetheless, it's of importance to ensure that your information and that your customers, your clients, and your suppliers are protected from being exploited upon that employee leaving the organization. To what does the restriction apply? Are they restricted, for example, from dealing with customers that they have ever in the whole 20-year employment they've had with you? Or is it a restriction from them using or dealing with customers who they've had contact with in the last 6 to 12 months of their employment? And this is where I find in practice you get yourself embroiled, and you have to get yourself embroiled in lots of definitions and interpretation sections in contracts, because whenever there's a restrictive covenant, it tends to come with at least 12, 15, 20 definition sections about what the relevant time is, what the relevant area is, what the relevant period is, etc., etc., etc. In enforcing restrictive covenants, I won't spend too long on this, because we all know that you can get, if you seek to enforce restrictive covenants, declarations, damages, and injunctions, and more frequently than not, the key remedy which anyone is looking for in the hope of unlocking and or potentially finalising the dispute is the interim injunction. Now, I won't rehearse the American cyanamide principles for anyone, because we all know what they are. But it does strike me that I should, as a polite reminder, and this was even a polite reminder to me actually when I was going through the seminar, the Lansing-Lind test. And this is important to remember, because if, for example, the restrictive covenant expires before any trial is likely to come before the court will take a closer look at the merits and the substance of the enforceability of the restrictive covenant. Whereas in the American cyanamide test, one's just looking primarily to see whether there is a triable issue. If you are going to be in a position of, as in Lansing-Lind, the court is more likely to take more scrutiny and closer scrutiny to whether or not whether or not the restrictive covenant is going to be found to be enforceable at trial, which is a slightly higher standard for your client to overcome. I refer you, paragraph 15 of the handout, to the case of Force and others and Sakama Limited. Now, this one is of some interest, because springboard injunctions, I would say, are probably less common than your standard injunctions seeking to stop your ex-employee who you hate doing anything. Springboard injunctions are there and designed in order to prevent a benefit being derived from your ex-employee exploiting your confidential information, or from taking your employees and going off and setting up their own business. So in the case of Force, this was a case, and I set it out in summary there, paragraph 15. That was a case where there was alleged conspiracies and agreements between the defendants at a time when some of them were still employed and were directors of the ex-employer, to procure ex-employees, essentially run off, set up a business, and make lots of money for themselves to the detriment of the ex-employer. In that case, what the court allowed was a springboard injunction in order to prevent any of those people from deriving said benefit. That does not mean they cannot derive or set up a business ever. The point of a springboard injunction is to prevent them from gaining the unfair competitive advantage they gained by not having to take the time to find good employees, to find customers, and to find suppliers. So, for example, it may take them an extra 6 months to do that if they were to do it legitimately. So you might be able to get a springboard injunction for that 6-month period, which gives your client, as the ex-employer, time to go and speak to every single supplier, every single client, and do a lot of schmoozing in that 6-month period to ensure that they do not leave you and they stick with you and they do not go with your ex-employee or their new business. Just briefly, some issues or some other enforcement issues which I think are important, because these do often get lost. For example, the first one is a classic that I see. The question is, was there consideration for the agreement to enter into restrictive covenants? Routinely, I see employers who think that when you just hand over a new document called a contract of employment to someone who's already employed by you, they feel that they can just slip into it various restrictive covenants which didn't exist before, and that all of a sudden, without increases in salary, without changes to bonus, without any extra benefits being incurred or inferred upon the employee, they somehow think that they then obtain the benefit of these restrictive covenants. I would say they likely do not, because where is the consideration applying ordinary contractual principles from the employee, or from the employer, I should say, actually, for the benefit of those restrictive covenants? That goes back to just fundamental contract law principles, but employers, I find, often fall foul and think that they're getting away with something which they're not. Repudiatory breaches by the employer, brackets wrongful dismissal and constructive dismissal. For example, is the employer in breach of the term as to notice and or notice pay? Have they failed to pay someone the correct notice pay? Have they failed to give them notice where they should have done? Are you embroiled in what is likely to become an argument around constructive dismissal, i.e. the employee saying that you have acted in fundamental breach of the contract of employment sufficiently such as to allow them to resign and thereby terminate the contract of employment? If that is so, then you cannot, as an employer, rely upon the terms of the restrictive covenants. And the other point I make is this: that is not uncommon, because I find, and this is particularly so with small to medium businesses, if it goes wrong between directors, for example, or senior management, it goes really wrong. I don't know what it is, but there seems to be a lot of, I'm going to come to this, but a lot of emotion in business. When you're in a small and medium business, you think as soon as you've got a senior manager who leaves, I see it frequently, they just hate each other. And there are daggers being pointed left, right, and centre, the swords come out, and those swords turn into litigation. If you are the first to blink and you put it upon the employee to face an application for an injunction, for example, is your client going to be met with a counterclaim, and perhaps even a better counterclaim than your claim, for damages for a unfair dismissal, for breach of contract or similar? Be careful. Garden leave, I won't go too much into that, but that's another tool, as long as it's in the contract of employment, to give the organisation some protection by simply telling someone to go home and do nothing. Claims against third parties, this is, in my experience, less common, but something which I think anyone who has a client coming to them saying, we've got an ex-employee who's breached one of their restrictive covenants, you may and should give consideration to. So, for example, what about the new employer who's employing your ex-employee? Do you have a potential claim against that new employee? For example, inducing a breach of contract or conspiracy. Is it possible that you might actually have a better claim against the new employer than as against the ex-employee? They tend to have deeper pockets, and it might well be that if you look to sue or at least put pressure pre-litigation onto the new employer, they may go the other direction, get slightly fearful, and start seeking to persuade the ex-employee to do as they're told and stop breaching their restrictive covenants. It gets you the same outcome, but in ever so slightly different way. So tactically, it can have some advantage. The downsides I find is in circumstances where you're looking to sue a third party, it can be commercially sensitive, and I find it a little bit more difficult to prove. For example, how do you prove that the new employer knew of the restrictive covenants which the ex-employee had prior to them taking them on board? How do you prove that they did anything, wittingly or otherwise, to induce or cause or conspire said ex-employee to act in a way which was in breach of their restrictive covenants? Are you realistically going to go off to your clients using your commercially sensitive information and say, please can you give us a witness statement to prove that this ex-employee and or their employer have approached you in the last week and that they were looking to take all of their business from us to them? That, I would suggest, is commercially and business-wise not very clever. So what do you do? Practical tips, and this is where I think paragraph 25 is another hopefully useful set of pointers you may think about when a client comes through your door. First of all, I've already alluded to this, but take the emotion out of it, take the heat out of it. It is nearly always the case that this employment relationship ended in a fraught, fractured way. You will probably have someone who's got a lot of money coming into your offices saying, I cannot believe this person has done this to me. I cannot believe how dare they try and take my customers, etc., etc. I'm going to do everything possible to bring them down. I'm paraphrasing, but I think we all know what I mean because I've certainly seen it. Take the emotion out of it, take the heat out of it, and put the business hats on for a second before any action is taken. Stand back and consider with the client the list of factors I referred to earlier. First of all, about the restrictive covenant. Legally, is it enforceable? Is it likely to be enforceable? Is it likely to stand the test of time? Because if you have to go all the way, these things don't always just stop at the interim injunction application. Yes, they do often, but your client needs to be prepared and committed for the long haul, because there will be an expectation that a claim will be issued substantively at the same time as, or very shortly thereafter, that injunction application, the interim injunction application being made. They need to be prepared for that, and they need to be prepared for that going all of the way. And what evidence have you got? Again, this is quite a difficult area, I find, in order to get proper evidence to prove that the ex-employee's done anything wrong. It's one of those areas, for example, where are you going to go to your client or your customer and say, can you give me a witness statement which says X, i.e. that he or she contacted me and they were trying to take my business? Commercially, is that very wise? I would suggest in most cases, probably not. Thirdly, and this is where I think is probably, if you don't take anything else away from what I've said today, please take away paragraph 27 of the handout, because I think this is probably the most important part of the handout. Is it worth it? Now, I know us as lawyers love to litigate. We want to litigate. We want to make sure that we're looking like we're to the client, protecting every one of their interests, and yet we're going to get them, we're going to get this ex-employee. But stand back a second and think, is it worth it? For example, what's going to be gained from the application? Are you really going to gain anything? Clients should realistically, I would say, have confidence in their business, confidence that they can rely upon their business model and go to their clients and schmooze them, I think was the word I used earlier. Make sure that you do all you can to keep your clients. That is a far cheaper way, in my experience, than having to litigate to an application from interim injunction or to litigate all the way to trial. What injunction or order is sought? Less is more. Don't just throw the kitchen sink at it. Stand back, speak to your client and say, what are you actually looking to protect? What's the use in trying to protect 3 of the breach clauses when actually your client's only really looking to protect 1 of them? It will make your client look much more reasonable, much more proportionate if they turn up to court with a single order they are seeking rather than a myriad or library of 3 or 4 or 5 different orders. Costs is a no-brainer. Costs in this field can become extremely expensive, extremely fast, because there is a lot of front-loading when it comes to enforcing restrictive covenants and making applications to court for injunctions. What's the financial wherewithal of the ex-employee? Your client may well be throwing a great deal of cash at something and they're never going to see a penny of it back. So be careful. So if it may be that it is worth it. It may be that if you stand back and you think, I'm about to lose a client worth £2 million, it is worth every single penny for me and this client to pursue this interim injunction. But if what you're pursuing is a potential client or a client you think you were going to get, but you're not really sure you were going to get, stand back and think, is it really worth it? It may not be. I sound like I'm doing myself out of business here, actually, the more I speak, but I'm being frank. What if the client's application fails? This is really important because your clients are likely to end up at a public hearing. What if you have a judge? They may be able to put up with this. What if you have a judge who says, I don't really like that restrictive covenant? And you've got 100 other employees who are on exactly the same restrictive covenants. What's that going to do for your business? What's that going to do for your restrictive covenants? Probably not a great deal, unless they are, as I said earlier, solid. Undertakings. There is an expectation that one would at least seek undertakings prior to launching an injunction. And I repeat what I said earlier. Only ask for the undertakings that you actually need. Do not ask for the undertakings that your client does not need. If you do that, it becomes so much easier to reasonably reject and refuse to give you those undertakings. So ask for what you need rather than what you don't need. Can the ex-employee be tempted to come back? You might not want them back, but sometimes if with a bit of ingenuity and a bit of PR, you can rebuild a relationship where you previously thought it was broken, and then you may well be able to fix the problem that way. I've already raised about the question mark of, are you poking the bear? Are you poking counterclaims in your client's direction by jumping first or blinking first? And think about reputation. Now, often clients will come to you and say, I'm looking to protect my reputation, I'm looking to protect my brand, we've spent years building up this business. But think in the other direction. Just think, what damage could happen to my reputation if this does go wrong? If we bring this to court and it goes wrong and we're found to have acted unreasonably, what could it do for your reputation in a public hearing, in a public forum? And if the answer to all of those things is, it is still worth it, and there will be cases where it is still worth it, then go for it. I'm not trying to deter anyone from doing that because you're entitled to enforce valid restrictive covenants. What I'm trying to do is to try and ask employers to stand back, take a think and have a look. Is it worth it? Don't delay, that's obvious. Delaying too long may well of itself be fatal to any application for an interim injunction. And fifthly, and if, again, as I alluded to earlier, the interim application is not the end of it. Routinely, I see cases where, and I've seen a couple where the interim injunction's had, but then the case has still progressed. Of course, if there is an interim injunction, quite often that resolves the matters because one way or t'other, someone gets what they're looking for, and it almost takes the heat and the sting out of what might become the substantive cause of action. But that doesn't always happen. And you can end up in very lengthy, long litigation at tens and tens, if not hundreds of thousands of pounds later, pursuing something when at the very beginning, if you had stood back, your client had stood back and thought, is it worth it? They may not have done so. And only if you can say, is it worth it? And the answer is yes, would I suggest that you take the step of litigating, which is always the measure of last resort.